Well, good morning, folks, and welcome to an Ag Allies call this morning. Thank you for being with us. We know there's a lot going on in the world right now. There's a lot going on in your personal lives, I'm sure, with school starting back and trying to dodge thunderstorms. And certainly our hearts and minds this morning are with the folks out in Western North Carolina that are dealing with a pretty unprecedented weather event yesterday with 8 and 9 inches of rain. And so pause just a moment to say thanks for being with us. Thanks for being a part of the Ag Allies community. The Chamber certainly views its role as making sure the overall business community is in touch and is working with the ag sector in our state, which is, a good 20% of our state's economy. And this is one of the forums in which we do that. So welcome. We're glad you're with us. We think this is an important discussion, and we look forward to having it with you. On behalf of the North Carolina Chamber, my name is Ray Starling. I am the General Counsel here at the Chamber. So I'm one of those lawyers, but you're not going to have to hear from me quite as much as you are 3 other lawyers this morning. And I also am the president of our Chamber Legal Institute. I'll pause there just to mention a reason we're having this discussion is I think those of us in the ag community realize that the legislature or the Congress or the executive branch of our state or federal government are not the only places where policy decisions and outcomes are impacting our businesses. For years now, we've said at the Chamber Legal Institute, we have to be watching what happens in the courts at least as much as we're watching what happens in those other forums. And so with that said, that's exactly what we're going to be talking about this morning. 3 developments from around the country that have some impact on the ag industry and the ag sector across the United States, but also here in North Carolina. Just a couple of housekeeping matters to begin with before I'll introduce Amber. First of all, you are muted to avoid any distractions. So should you want to be in touch with us, the best way to do that is to put something in the chat box. But you also are directed and asked, frankly, to put questions that I will then pose to our panelists in that chat box. So Talisa has just sent you a reminder of that, so please feel free to fill that in. I want to now move immediately into our speakers. That's what you're here for. We're going to start with Amber Miller. Amber is a personal friend, and that is largely because of her engagement and involvement over the years with an organization that she and I both know and love called the American Agricultural Law Association. I will never forget telling someone at my church years ago that I was excited to be leaving town to go be a part of an American Ag Law Association CLE, a continuing legal education event in some far-flung place in the United States. And I will never forget him looking at me directly in the face and saying, "That sounds awful." I was absolutely offended because I love going to the American Ag Law Association meetings, hearing about what's going on in the ag law space. Amber has always been an acolyte, a leader in that organization. In fact, she served as the president of the organization, which means she's also just wrapping up her role as the past president on that board. That's taken a lot of time. I want to give her some credence and some gratitude, frankly, for her service to her fellow ag lawyers in that role. Her education is interesting. So Texas Tech undergrad, grew up in Texas. Texas Tech got a BS in animal science. At Texas Tech. Then she goes on to get a Master's of Science in Meat Science at Colorado State. And having not had enough punishment in higher education at that moment, she then went on to Drake University, which is really, frankly, one of the 2 marquee ag law schools in the country. That ultimately got her in touch with some folks up in South Dakota, where she ended up being the general counsel to the South Dakota Department of Agriculture, a deputy secretary there in that role, and an ag policy advisor for a guy who now happens to be a United States Senator, then South Dakota Governor Mike Rounds. Amber worked at Crenshaw, Dupree, and Milam in Lubbock, Texas. And so Lubbock is one of those great towns that has everything you need. In fact, if you were to cyber stalk Amber and her firm, you would find that there's a Panera Bread right outside the door and a Starbucks on the other corner. But before you start drawing the wrong conclusions, I should also tell you that Amber is a regular down the street at a place called Slim Chickens, which when you find out the kind of food they serve, I'm not sure Slim is truth in advertising, but we'll leave that up to the good folks in Lubbock to regulate. She has 2 kids, 7 and 4. Amber, we're so happy to have you here. We look forward to your conversation, particularly with your background in meat science and your knowledge around the pork industry and your connections there. The Proposition 12 event out in California has the potential to be, if not cataclysmic, certainly will have some impacts on all of us, even on farms back here potentially in North Carolina. So Amber, look forward to hearing your comments. Appreciate you being with us. And I think folks are going to be excited to hear what you have to say.
Thank you, Ray. Gosh, with that lead in, I'm not sure how the crowd is responding in the cyber world. You've been so bored to go to American Ag Law Association, and now you know the dining capabilities here in Lubbock, Texas. Listen, it's truly exciting to be here with you all. Thanks so much to Ray for the opportunity to visit with you folks this morning. Proposition 12 is a topic that I'm sure most of you have seen headlines about, maybe especially lately. I'll tell you, I do some work as outside counsel for the National Pork Board. The attorney disclaimer statement of that nothing I say here today is in my capacity as lawyer for the National Pork Board, but only in my own personal views. But I'll tell you that most of my friends that know that I do work for the Pork Board and family members have been sending me email articles of there will be no more bacon in California starting in January. And so the interest in Proposition 12 is definitely increasing, although it is a proposition or a ballot initiative that started back in 2018. So we'll go to the next slide and we'll unpack a little bit about exactly what Proposition 12 is and give a little background of why it matters. Again, California has a unique ballot initiative measure process. As Ray mentioned, as opposed to necessarily debating it in the halls of the California legislature, this is a way in which the population can take an item of interest and approve a ballot measure, which is then adopted. The title of Proposition 12 that has been, I think, conveniently added is Prevention of Cruelty to Farm Animals Act. Candidly, there are no findings that any of the provisions of Proposition 12 necessarily have to do with any cruelty to farm animals that's been taking place. But that is the advertisement of the term, the label that was put on Prop 12. It doesn't apply to just hogs, right? It is for fresh eggs, shell eggs, veal, and whole pork meat. So as it relates to the hog industry, which obviously is a very important part of the North Carolina economy, it's important to know that this particular provision bans the sale in California of whole pork meat products that come from animals that weren't raised in accordance with Prop 12. So what does that mean? What Proposition 12 says is that there are certain standards that live breeding hogs have to abide by. And those standards are new spacing requirements. There's also some vague language that animals need to be able to turn around freely, lay down and stand up without touching other animals. And then the devil's always in the details, of course. Those additional requirements also have to do with accreditation of all live hog places and making sure that they abide by the spacing. They have third-party accreditation firms that are to come visit your farm. There's certain self-certification and formal certification to submit to the California Department, and lots of record keeping and labeling requirements that are still being formulated. Just so you know that the spacing question amongst folks that understand hog production always is, what does that really mean? Typically, most sow barns are anywhere between 14 to 20 square feet in most of your large hog production operations. The California requirement now will be a 24 square foot requirement per sow. So with that background, let's go to the next slide and we'll talk about now what with Proposition 12. From a court legal challenge standpoint, okay, you may have followed some of the headlines. The National American Meat Institute, or NAMI, as you commonly know of that organization, did file a challenge to Proposition 12 on some constitutional basis and grounds. A separate challenge was also filed by the National Pork Producers Council. Similar constitutional grounds. We don't have time today to go into all of the details of those challenges. For our purposes today, it's important to note those challenges have failed. The Ninth Circuit has deemed that Proposition 12 is constitutionally valid. And the Supreme Court has failed to accept the petitions that were filed by those various parties to challenge Prop 12. So it's here, okay? What does that mean? And the next series of bullets, I think, are the most important for those that are involved in live hog production as well as in processed pork production, is the implementation timeframe. And remember, this initiative was passed in 2018. And when the initiative was passed, Proposition 12 required the California Department of Food and Agriculture to issue regulations by September 1st of 2019, recognizing that it would take quite some time prior to the January 1st, 2022 deadline for live hog operations to make the changes to comply. But here we sit today on August the 18th of 2021, and those regulations are still in the draft stage. I'll tell you, I hopped on the California Department of Ag's website this morning, and they were accepting comments on their draft regulations until July the 12th. During that comment period, they received requests that an open hearing would take place. And so an online hearing will take place here August the 27th of this month, but the department still has time, right, in a due process standpoint, after receiving those comments and after having the hearing, to still potentially make changes. Naturally, that's caused a lot of uncertainty within those that are in hog production, because we've got less than 4 months here to know exactly what those regulations are going to be before this Proposition 12 becomes law and all pork coming into the state has to comply with the deadlines. Just to give you a little flavor of what that means, Rabobank has done a ton of work in this space and estimates that less than 4% of the US sow herd right now can meet this 24 square foot standard. And not only the time, but the costs that are facing hog farmers across the US are staggering. Between $900 to $1,800 a sow is estimated in terms of increased building costs just to provide the space. Next slide, please. And so what's next? Of course, NPPC has been advocating on behalf of the 67,000 hog producers in the US that once we allow the California Prop 12 to pass, and we have another patchwork of state regulations, I've listed the other states that have similar measures that have either been proposed or passed in the last 2 to 3 years. You've got almost what amounts to state trade barriers, right? Because you've got different rules that apply in each of these states. And while it would be easy to say, well, forget California, they've got the largest population in the US, right? In fact, they consume 15% of the pork produced in the US. It's a staggering number. And so when you've got large retailers and food service companies, they can't just ignore California, and they're going to put these requirements on these hog producers if they want to go through the retail and food service channels. One thing I think is interesting is just, as I've raised a little bit, the questions about the timing and the implementation. Again, California Department of Ag's website, I was gleaning through just what kind of advice they're providing for folks that are asking. And you've got this strange conundrum of, well, if the hog is born before January 1st of 2022, then you can certify. There is no need to certify. They're technically compliant, right? Because Prop 12 doesn't come into place until January 1st of 2022. So what about those pigs born January 1st? You can't make a certification that they were produced in compliance with Prop 12 because you haven't had the time to make adjustments to your barns yet. And so we're in a strange period here for about 10 or 12 months in terms of, what do we do? What pork meat will be allowed to be imported, and how will California approach that? And next slide. Last few comments here. I know we're limited on time this morning. Just some things to highlight for you that I think Proposition 12 highlights for me in terms of this larger conversation about legal battles that are impacting animal ag. First, I'll just say, I should have done this at the beginning, my picture of the cute little pig, right, over here on at least it's on my right, and my law firm logo. I showed these slides to my husband last night, who works in the food industry, and he poked a little fun at me of the picture of the pig and said, gosh, don't you remember animal science? days? And have you become such a, pointy-headed lawyer that if you get what a real hog looks like? And I grinned and I told him that's the problem, right? Because little baby pigs are cute and snuggly, and they're fun to talk about and advocate for when you have pictures like this, coupled often with a law firm logo. That combination has become very dangerous for production, animal ag, and things that we could talk about for hours and days. And so I'll just leave you with this, that the Prop 12 to me presents several paradoxes for those in pork production, right? California, no significant commercial pork production in that state. And again, the California Department of Ag will go on and state how this has a very limited impact on their pork production industry. Of course, because there's not much there. Yet, you have the rest of the U.S. pork industry trying to supply product to a state that consumes 15% of U.S. pork production. Again, another paradox is you've got these folks who have worked diligently, right, to have not only gains in production efficiency, but also gains in environmental efficiency and using less building materials and using less water. And yet, if you comply with Prop 12, what does that mean from a carbon footprint standpoint as we add building materials, as we add more spaces to wash and clean? And finally, just one that applies to all of agriculture right now, we're facing tax proposals. And I think of taxes when I think of additional cost and fees for ag producers. And we say that all these are beneficial and necessary to keep the economy going. And yet we all know that likely that means that the big will survive and the small will not. And yet we have an executive order on the enforcement against large buildings and competition. So just some subjects to think about and to pontificate today as we move forward. Ray, thanks so much for the opportunity. And I'll be quiet until we have questions at the end.
Amber, you can bet you're going to get some questions. So thank you for making that seem simple and straightforward. I loved your comments at the end about the cute little snuggly pig there. We all have a friend here in North Carolina that was a significant face in the pork industry until the last week or so, who would talk about how badly old MacDonald had a farm sets us up for failure in terms of what people think about modern agriculture. Sarah Mock writes about that in her recent book as well. So a lot to absorb there, but your comments about the culture kind of hit home as well. Speaking of culture, let me tell you a little bit about the culture that surrounds our next speaker, Tiffany. Tiffany is a very hard worker. I got to know her. She was also a board member of the American Ag Law Association, and just a tireless worker, very efficient, very hardworking. In fact, Tiffany, if I'm not mistaken, you finished a double major in 3 years at OSU. Am I close to right on that?
Well, close. I had a year of a judging team scholarship at a junior college, so technically there was 4 years.
Okay, fair enough. Well, still, you're one of those OSU Cowboys, now relocated down to Texas. Went to New Mexico, University of New Mexico School of Law. But probably the most memorable thing about Tiffany, in addition to her work that she does in the ag law space now, frankly, on behalf of Texas producers and farmers, she's what I would call essentially an extension ag lawyer, meaning she is out in the field. That is a part of her appointment there at Texas A&M, and really just great podcasts, great presentations, a lot of great content from her on social media. So if you're not following Tiffany on Twitter and some of the other forums, please make sure you're doing that. But the quick story before I give you the mic, Tiffany, is just following you on Twitter. Not only do I learn things about ag law, I learn things about what it must be like to live in West Texas. Earlier this week, they got rain, which is apparently something that happens very sparingly there. And so her 2 children, who are both young, decided to hang their heads out of the side of the truck while the driver drove through a mud hole and splashed water up on them. And so the fact that Tiffany was not bothered by that or didn't think that was a problem, and the fact that the kids thought that was so exciting, tells you a little bit about how dry it must normally be out in West Texas, and how hard pressed you are for entertainment out there. So no wonder you're so dedicated to agricultural law. Maybe there's not that much else to do. But Tiffany, you're going to talk to us today about who can and who can't come onto the farm, at least according to the Supreme Court. this past term, a case arising out of California. We look forward to hearing your comments on that because it does seem like that there's a lot of outside interest in what we're doing on the farms these days, and a lot of folks feel like they ought to get to pop in whenever they want to. So let's take it away, and we look forward to hearing your comments and your observations.
Absolutely. Well, thank you, Ray. I appreciate it. And like you say, when you come to visit us, I'll give you a couple of West Texas life lessons. But the first one that we all know is that you never complain about rain. And so in my house, if that means we get to get splashed while we're driving down the road, man, we're going to take it and we're going to celebrate it. So I appreciate the opportunity to be here. Like Ray said, we're going to talk about a U.S. Supreme Court case that involved a couple of agriculture growers. And so I think that this is, news across the country for ag producers. Anytime that there is a win for an ag grower or producer in the U.S. Supreme Court, this case is interesting on a practical level. I'm not sure how generally applicable it will be just because it's under some pretty specific facts. But I think it's interesting to look at from an ag producer standpoint. So Natasha, if you'll go to the next slide, we'll to give a little bit of background here on this case. Essentially, there's a California law that gives employees or ag employees the right to self-organize as far as unions go, and basically says, if you're an ag employer, you can't prohibit that right. They've got a real comprehensive labor relations statute in California, and the Agricultural Labor Relations Board passed a regulation that basically said, okay, we're going to require ag employers to let union organizers come on their property to talk to their employees. There were some limits on that. It wasn't just an unfettered right of access. And the statute basically said they could come for up to 3 hours a day. It was 1 hour before work, 1 hour at lunch, and 1 hour after work. And they could do that for 120 days a year. So, right, essentially the Labor Relations Board is saying, okay, private farm and ranch owner, you have to open up your operation to let union organizers come talk to your employees. That's the state law. So if an employer was guilty of interfering with that, they were guilty of unfair labor practices, there were some sanctions that they could face. It was a violation of the law. So Natasha, if you want to go to the next slide, and if you want to just click through all the bullets on there, you can just click through all those. Perfect. So we'll talk about kind of the lawsuit that was filed. So there ended up being two produce growers, and they filed a claim that said this statute, or this regulation in California that allows access violates their rights because it's a taking of their private property. And in particular, what they were saying is this is a per se taking. So in takings law, there's kind of two big bucket categories. If there's a physical taking of property, that's called a per se taking. And if that occurs, compensation has to be made by the government, right? The other one is where things get a little trickier, and there's kind of a balancing test, and courts really look at the facts to decide if on balance a taking occurred. In this case, what they said was, because you're letting these people come on our property, it's a physical invasion, and you have to pay us just compensation because you've taken this private property right. So they sought, and this is going to be interesting here in a minute, what the plaintiffs sought in that case was declaratory and injunctive relief that basically said, hey, California Ag Labor Relations Board, you can't enforce this regulation against us, right? They wanted the court to say, you can't enforce this because it's an unconstitutional taking. The trial court dismissed the case and said, hey, this isn't a continuous and permanent access, right? They can only be there certain days and times, and unless there's a continuous presence, it's not a per se taking. The Ninth Circuit agreed, and they said, no, it's not a per se taking. Maybe if you use that balancing test approach, we would have a different result. But the plaintiffs didn't plead that. They didn't ask for that. So they affirmed the dismissal. And then the growers filed a petition with the U.S. Supreme Court. So the next slide, we'll talk about the opinion that came out of the United States Supreme Court. And Natasha, you can just click through all those bullets as well. So this opinion was written by Chief Justice Roberts, and the justices that joined the opinion were Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. And what they said was, hey, we actually agree with the growers and we think this is a per se physical taking. And if there's a per se physical taking, that means that they are entitled to compensation for that taking of their private property. And the way the court phrased it is they said that what was taken was the property owner's right to exclude. And so they kind of went back to that. It's a concept we learn in law school called the bundle of sticks, right? Where if you're a landowner, you've got this bundle of sticks or bundle of rights you have related to your land. And if you take away the right to exclude people, you've taken a part of that private property rights. And so that's how the court dealt with that. They said that there does not have to be a permanent or continuous presence for it to be a taking. So they just disagreed with that conclusion reached by the lower courts. They distinguished a case that really, I think that both parties or the California Labor Relations Board spent a lot of time on. There's a case called Prune Yard, and in that case, there was a shopping center and some people wanted to come and leaflet, right? Hand out materials to folks at the shopping center. And the court said they were allowed to do that. That wasn't a taking. The Supreme Court, the majority opinion here said, wait a minute, we think there's a big distinction here because that shopping center was open to the public. These farms were not, right? And so they drew that distinction, and that's why they didn't get the same result. The last thing that the court spent a lot of time addressing is what I'm calling the potential broader impact of this decision. And essentially the Labor Relations Board or the state of California and the dissenting justices said, wait a minute, if you say that letting someone come on property is a taking, you've just upended a whole bunch of state laws and regulations that allow that. And the court said, wait a minute, we're not going that far. And they sort of articulated three limits on this. So one thing they said was, this decision doesn't change the distinction between trespass and a taking. What that means is if somebody just comes on your property periodically, that may be a trespass. That's not a taking like this regulation that made you open it up at least 120 days a year for 3 hours a day. So that's one distinction. Another distinction is a government authorized physical invasion is not a taking. And so one example that they gave there is if the government has a search warrant, right? If the cops show up with a search warrant, that's not a taking because they are authorized to do that. The final exception that they gave, I think maybe one of the more important ones, and they said it's not a taking if the property owners essentially concede that right as a condition of some sort of benefit. So for example, if you get a permit from the state to operate some business on your farm, and as a condition of that permit, they have the right to come do a health and safety inspection. Well, that's not a taking because it was a condition of that benefit. So they drew those distinctions to sort of say, listen, this decision, we are deciding this on these facts, but it's not going to sort of create this parade of horribles that you might see listed out in some of the other arguments or in the dissent. Next slide, please. And so there was a dissenting opinion, and that was filed by Justice Breyer, who wrote the opinion, and then Justices Sotomayor and Kagan concurred or joined that dissent. Essentially what they said there is, wait a minute, this regulation didn't appropriate or take anything. All it did was regulate, right? It didn't take their land. It didn't take their right to exclude anybody. It just regulated that, and landowners are subject to regulations. They did believe, like the lower courts, that a permanent right of access is required for there to be a per se taking claim. They said if there's a non-permanent invasion, then that should be analyzed under that Penn Central balancing test, kind of the other bucket of takings that we talked about. And then they put forth that concern we sort of discussed a minute ago, that there's a number of ordinary regulations that are now going to be a taking, or that are at least going to cause a bunch of confusion for people and may result in a bunch of lawsuits filed to try and sort out the parameters of this decision. So sort of on our final slide, Natasha, if you will hit the next one, a few key takeaways here, I think. One of them is that courts, the US Supreme Court has now expressly recognized the right to exclude people from property as a property right, okay? And they said that this right to exclude, if that is taken, it can be a per se taking because it's like a physical invasion, right? We do know that it does not have to be permanent and continuous access to create a per se invasion. And then here's where I think it gets interesting. We don't know what the practical on the ground outcome of this is going to be. The court did not say that the statute itself is unconstitutional. What they said was it's a taking and just compensation would have to be made in order for that statute to be, in effect. So will the court or will the California Ag Labor Relations Board come up with some sort of payment mechanism where they say, fine, we'll pay you for the taking, but the statute's still going to stand and we're going to let people have access? I don't know, but I think that that's really interesting. Lastly, sort of the impact on the ag industry across the country, we'll have to see, right? I mean, this is an example again of where it was ag facts that were the basis of the complaint, but also it's pretty fact specific, right? It's this California law, California statute. So I'm not sure where it goes from here for the ag industry, but something certainly to watch from a private property rights standpoint. You may see this case pop up in other areas when those issues arise. So Ray, I'll turn it back over to you.
Right. It does certainly suggest that you cannot merely force entry onto a piece of property under state law without it with impunity, right? So I think it's promising to us in that regard, but I think your last point is well made. So thank you. We'll come back and have some more questions and some more discussion probably about that case as well. So rounding us out this morning is a gentleman who frankly doesn't need any introduction to the North Carolina ag community. And Jake, and I hope he doesn't mind me saying this, but I think Jake brings such an interesting background to our conversations because he's an App State alum, a Central Law School grad. I'm not sure I should mention this in mixed company here, but he's actually a Carolina fan. And so all that said, what kind of person is this? Well, I'll tell you this. He's clerked for 2 years on the state Supreme Court. He's the general counsel of our state's largest farm organization and most active organization. He is now the corporate secretary for that same entity. He's been the state legislative director there. He's been the federal legislative director there. He's worked on the Hill in Washington. In the ag space. So he brings a lot. And so I think it says, hopefully, to those folks that may have family members who have the non-traditional ag education in the state, meaning you went to an institution other than the ones we frequently mention, you can definitely have an impact and play a leadership role in this conversation, having come from a different educational background. And also having, frankly, grown up, I think, Jake, in Chapel Hill. So not necessarily on a farm, but certainly farm community has no better advocate than him at our disposal now. He's going to talk about that. And Jake, I think what's really neat about your presentation this morning is how much you've been in the trenches on the particular matter that you're going to be talking to us about. Jake has also served nationally and have been a part with Joe Miller and me of the American Ag Law Association. Jake is wrapping up his leadership service to the board there. And maybe one personal note, I've tried to make it a little bit personal about each of these speakers, but just to tell you about the moorings that Jake has, his wife actually this past Sunday, Stephanie, was ordained into the ministry down in Clayton. And I just think that's really neat. I think that the fact that Jake's 2 beautiful girls will get to grow up the children of a lawyer and of a minister. It reminds me, Jake, of the Commissioner Troxler's joke. He has one son that is a pastor and one son that's a lawyer. And so I think each morning the children should pray with their mother that they don't need the services of their father before sunup the next day. So we'll see if it works out that way at your house. But Jake, we look forward to your comments about a case currently pending here in North Carolina and for your insights and your guidance as we work through what's happening there. So bring us your remarks. Jake, you're still on mute, and what you have to say is way too valuable.
Well, I was saying thank you for the kind words, and it wouldn't be a video conference if somebody wasn't told they were on mute and they were trying to talk. So we've checked that box. And thanks for all the kind words about Stephanie. I'm very proud of her, and our daughters do get to experience the light and the dark every day with a pastor and a lawyer in their house. But in any event, I'm also thankful for the really close working relationship the North Carolina Farm Bureau enjoys with the North Carolina Chamber. It's a great partnership, doing great work on behalf of the state's farmers and agribusinesses, and we look forward to continuing that. And then to be on the panel with two close personal friends and outstanding agriculture leaders in Amber and Tiffany. I could sit here and listen to those two rock stars all day, talk about just about anything in agriculture law. Let me start off my presentation, knowing that we don't have a lot of time, with a quick caveat. What I'm going to talk to you about is the background and then some litigation that North Carolina Farm Bureau is involved in at the moment. And so I'm going to have to be a little bit careful about how I describe some of the issues that we're dealing with. But the issue is so important to the agriculture economy in North Carolina, and frankly to the state as a whole, that I felt like it was worth the risk to share some of these thoughts with you. So know that if you ask me a question and I duck it, it's because I'm being careful with how I handle that. So with that, Natasha, happy to go to the next slide. And this is your ag law nerd alert. Tiffany, Amber, Ray, and I are all ag law nerds, and we love to dork out on this stuff. But you may not be as familiar or really care much about the basics here, but we've got to get through some basic nuisance common law first. And that's the idea that nuisance is a common law tort. It provides remedies for the loss of the use of and enjoyment of property. That's the opposite kind of idea that Tiffany talked about with the right to exclude property. The right to use and enjoy your property is one of those bundles of sticks, or one of the sticks that go in that bundle that she talked about. And the point of all that is farms and agribusinesses are uniquely vulnerable to nuisance lawsuits. Think about it. You go on a farm, there's going to be dust. There might be flies. There might be odor. There's certainly going to be animals. There are going to be crop protection chemicals that are sprayed. There are going to be all sorts of, there are going to be farm trucks running. There's going to be combines going along. And so if you're not familiar with those type of activities, you could create a situation where there's some misunderstanding and some lack of awareness about what it actually takes to run a farm, which could lead to potential nuisance lawsuits. And so farms are just really vulnerable to these lawsuits. And when you read really old cases from the 1950s and 60s and 70s about agriculture, and their nuisance cases, almost always you're going to find the farm being determined to be a nuisance. And so that is a serious issue that state legislatures across the country have noticed. And all 50 states have adopted what we call right to farm statutes, that while they differ in type and effect, they're all intended to protect farms against nuisance litigation. And so North Carolina, Texas, Oklahoma have very similar statutes that create statutes of repose. That's a legal term we won't get all into today. But then you have some that deal with zoning ordinances, some that deal with good agricultural practices, some that use mile boundaries, all sorts of ideas on how you get at this. But the basic point of these right to farm laws is you're trying to insulate or protect a farm against a nuisance lawsuit, because as we all know, they can be very damaging to you. Natasha, let's go to the next slide. So let's start with this Murphy Brown Smithfield litigation, which I call a mass action. You may have heard of a class action, but a mass action is a case where you have a bunch of plaintiffs who are different in their maybe their situations, so you can't really establish a class action claim, but it's a large group of people who filed lawsuits together. And in this case, it was a mass action against Murphy Brown Smithfield that was originally filed in state court in 2013, but ended up in federal court in 2014. And there were 500 plaintiffs involving approximately 80 farms in North Carolina. This is an enormous piece of litigation. And as I said, those cases eventually ended up in federal district court in Raleigh. And the plaintiffs in those cases were alleging that the farms involved were creating nuisance due to odor, flies, farm trucks. And so it's just a basic nuisance complaint. But when you read the complaint, it really looks like a personal injury lawsuit, the way it was drafted. But in any event, these cases were filed. We in the agriculture community took notice and began to try to figure out how we could support Smithfield Murphy Brown and, frankly, those roughly 80 contract farmers, many of whom are Farm Bureau members. Natasha, next slide. So Those cases were filed, and I remember early on in the process, after I had gotten involved in AALA, Tiffany grabbed me one day at a conference and said, "What in the world happened in North Carolina with your lawsuits and the right to farm law?" And so I tried to describe to her what had happened, but what happened there is you have all these nuisance lawsuits, and you would think that North Carolina's right to farm law would protect Smithfield Murphy Brown and those growers against those lawsuits. But that wasn't the case. Smithfield Murphy Brown did assert a right to farm defense. And at the time, as you can see on the screen, North Carolina's right to farm law had 3 requirements that the farmer had to show. They had to show that the farm was in existence for more than a year, the farm wasn't a nuisance when it began operating, and that there was a change in condition that had occurred near the farm that caused it, or that caused the nuisance. We usually think of that as someone has moved into the area. A new owner of a house nearby a farm is a perfect example of what we believe the change in condition was. But the federal district court judge in 2017, who was presiding over these cases, ruled that North Carolina's right to farm law didn't apply, even when you had people who moved in close to the farm, because in his view, the land surrounding the farms had been used as residences, and they were still being used as residences, and there was no change in the conditions. And I remember the conversation Tiffany and I had, which was basically, if this is right, then you could put a housing development right next to a farm, and it would be not protected against nuisance lawsuits. You could have an apartment complex put next to a farm, and it wouldn't be protected. It wouldn't matter. Just as long as there was a residence happening around there under the judge's ruling, you could have a right to farm law be dismissed out of hand. And that, in our view, blew a hole in the right to farm law entirely, made it almost worthless. So what happened, and Natasha, let's move on to the next set of slides. So what happened was, after that right to farm ruling, there were 5 cases tried in the Smithfield cases. Urban juries, that is, folks from Wake County who don't have a lot, there's a lot of agriculture in Wake County, but a lot of people don't live nearby those farms in Wake County. Urban juries heard and decided these cases. We thought that was a fundamental problem with this whole process. And those juries returned nuisance verdicts, and some of them had astronomical damage awards. One of them, I think, was in the $450 million range, which is incredibly huge. And then I won't bore you with all the details of how all that played out, but in the fall of 2020, the Fourth Circuit affirmed the verdict in the first case, and Murphy Brown Smithfield entered into a universal settlement that resolved those cases as a whole. Next slide, Natasha. So in response to that, the North Carolina General Assembly, as it would in any other context relating to tort law, if you think about the best example I can think of is medical malpractice. The General Assembly saw that this litigation was going on, perceived correctly that it was a threat to the state's agriculture economy, and then began to take steps to prospectively correct that problem. In 2017, the General Assembly capped the damages that were available in farm nuisance litigation to the fair market value of the plaintiff's property. And then in 2018, the General Assembly made significant changes to the way our right to farm law works. Now, under North Carolina law, to bring a lawsuit against a farm for nuisance, the plaintiff has to show 3 things. First, they have to be the legal possessor of their property. That is, they have to be the owner or a lessee. Second, they have to reside within a half mile of the alleged nuisance. That's an idea that the General Assembly took from Michigan, which has a 1 mile boundary in their statute. And then finally, the plaintiff had to file the action within 1 year of the farm's start of operation or a fundamental change. And that idea was generally taken from states like Texas and Oklahoma, which have very strong right to farm laws. So that law was enacted. It was a big time fight in the legislature. For those of you who went through that with us, thank you for your support as we pushed hard. The Chamber, North Carolina Pork Council, North Carolina Poultry Federation, Commissioner Troxler. This was a huge issue for North Carolina's agriculture economy, and we were able to get it passed with veto-proof majorities. Unfortunately, we had to override a gubernatorial veto to get it, but this was a major, major win. Natasha, next slide. In response, in the summer of 2019, 3 nonprofit organizations that had opposed the law when it was moving through the General Assembly filed a state law challenge against the right to farm amendments. They challenged the law under North Carolina's Constitution, alleging that the bill or the legislation was a special law intended to protect only Smithfield Murphy Brown. Two, that the law violated North Carolina's law of the land clause, which is really our substantive due process rights, property rights clause of the North Carolina Constitution. And then that it took away their right to have their complaints heard before a jury. Those matters were fully briefed before a 3-judge panel, as we do it here in North Carolina, when you have a facial constitutional challenge. And that lawsuit was dismissed in December of 2023. And that was a really huge win for us. And I need to give a shout out to Chris Smith with Smith Anderson, who's on this call as a member of the executive committee of the North Carolina Chamber. He is our litigator on that case and did a fantastic job in helping us get through that process and getting to that victory. And I also have to say, Nate Huff, thank you for your leadership and all that you've been doing representing the legislative defendants in that case. The Attorney General's office has also been involved in the litigation, has been a great partner as well. So it was a really big win for North Carolina agriculture to have those cases dismissed. But as we expected, the nonprofit groups appealed that decision to the North Carolina Court of Appeals in January of this year. We are almost done with the briefing schedule. We're expecting one more filing from the plaintiffs tomorrow. It'll be fun reading over the weekend. But then we expect that we'll have an appeal oral argument calendared for probably maybe later this fall, or more likely into the winter of 2022, 2021, at which point the case will be heard by the Court of Appeals and we'll move forward. I'm hopeful that the Court of Appeals will affirm that decision from December. Natasha, next slide if I've got any. I'm not sure I do. That may have been it. I also want to say one other thing, to say thank you to Tina Latesy and Commissioner Troxler for filing an amicus brief in this case as well. They did a fantastic job of talking about how these right to farm laws are important to agriculture as a whole. And it was a really, really powerful brief. So we're grateful for their support and participation. But I hope I left some time for questions, Ray, and thanks again for the opportunity to be with you.
Absolutely, Jake. Thanks for taking a really, really big piece of, frankly, agricultural history in the state and making it so succinct, making it straightforward to explain how we are, where we are. And certainly good luck in the Court of Appeals. I think we all want to chime in and try to be helpful there as much as possible. It looks like the questions hopefully are coming. I want to process the one Paul just put in there, so I'm going to go to my pre-baked list and ask all three of you, Tiffany, Amber, Jake, if you would all turn your cameras back on and let me pose this to you. You know, we talk a lot at the Chamber Legal Institute about how the legislature, the legislative branch, is where we expect people to work out policy debates, right? That if anyone is supposed to be able to craft the rules of business and frankly, you know, how we operate in a democracy, in our state, it's supposed to happen on John Street, where our legislative building is. What's interesting here, though, I think, is we've certainly seen a policy debate move into the court. I mean, I don't think there's any doubt that's what's happened in California with Proposition 12. That's what has happened in North Carolina with our right to farm law. As Jake points out, the very people that opposed the passing of the legislation have now acted legally. But what's interesting is in Tiffany and Amber's cases, the law existed and the ag community is trying to get it overturned. So, and was successful in Tiffany's case, the Supreme Court case. In Amber's case, not yet, and appears like, you know, not a great path there for that. In Jake's case that he talked about, the law exists, the law got passed, and now the ag community is trying to preserve it. And so in either case, in one ag's playing offense and the other we're playing a little bit of defense, do we have the tools we need to do that? What would you love to see us have more of in terms of the ag community's flexibility, capability, prowess in coming to these fights? And with that, you know, a shout out, frankly, to North Carolina Farm Bureau and what they've done just monetarily. I mean, there have been, you know, there are others that are in these fights as well, but none leads from a monetary perspective quite like the North Carolina Farm Bureau. And so react to that, if you will, folks. What else should we be doing? And Jake, I know you and I have talked about this some, so I'm going to ask if we can start with you and then we'll go to Tiffany and finish with Amber. And I won't interject in between, but let's start with Jake, then Tiffany, then Amber.
Yeah, let me start off by saying I was remiss not to do this earlier, but North Carolina Pork Council farm credits. I saw Vance Dalton on here, have been great supporters of North Carolina Farm Bureau's legal foundation, as our county farm bureaus across the state, and that helps. And we need, frankly, more of that support. I think to your point, Ray, and I know Amber and Tiffany, we've all talked about this. We need some kind of mechanism that allows us to have a kind of rapid response to what we see happening litigation wise in the United States. We're just not equipped to keep up with, on the whole, all that's happening across the country. But maybe we can come up with a regional approach where we can rely on people like Tiffany and Amber in Texas, or Joe Miller in Indiana and Illinois to keep up on top of what's happening and then be able to respond. But that requires money, and it requires talent and resources. I would encourage all of you, if you know a young 2L, 3L who's interested in agricultural law, get them engaged somehow, please, because we need more agricultural lawyers. We just do. We need more people who know it, who understand it, and who care about it to take this forward. So if you want to have an offline conversation with me, shoot me a note and we'll talk. We'll get you looped into this little conspiracy that we have going. But it's going to take resources. It's going to take creativity, and then just great people. So,
Tiffany, chime in.
Yeah, I'll piggyback a little bit off of what Jake said. And I mean, this is going to sound like the typical Texas answer to you, but I think we need more boots and cowboy hats in the legislature. I think that's a real problem that we've got, is we don't have enough people who really understand ag that are in, whether it's a state legislature or on the Hill in DC. And so one thing that I tell students who are interested in agriculture, whether it's ag law or anything else, is, look, we need people out there who are growing our food. Obviously, we need farmers and ranchers, but we also need ag people, right, in boardrooms and hospital rooms and courtrooms and the legislature. And I think that that's something where there's a lot of opportunity. And I think maybe we need to do a little bit better of a job with our high school and college students, sort of teaching them there are those opportunities and helping them find those careers, because I think we desperately need people in those roles.
Couldn't agree more. Completely agree. And Tiffany and I are probably fussy about our own local state legislators and congressmen. We need more boots and hats, even our own. But I'm gonna quibble a little bit with Jake and piggyback off of Tiffany. It's not just a response, right? But I think it's a planning effort. And I think we've fallen behind sorely to train young people in high school, college, and especially law school to be ready, whether it is at a practicing lawyer or within policy jobs. I think we're losing the battle as it relates to training lawyers. And so we are being outrun by law schools and policy centers who may have some ideological differences than the folks on this call and the folks that we represent. And we've talked around that several times, but I think Jake's 100% right. We're getting outrun. We don't have enough people. So what do we do? And I think there's definitely a space as it relates to, as Tiffany said, high schools and undergrads, but also law schools, to have good people and to have good law firm or law professors. What does that mean? Probably funding and money from businesses to law schools to support that effort. And I think that's really the question, Ray, is are we prepared to put the money there and support that training of new young people?
Yeah, and I think it's funny, Amber, one of the, it's almost like there's two different cabals, if you will, of ag lawyers. There's the AALA sort of land grant background, grew up on farms, connected, and then, and I don't mean to disparage them at all, but, and frankly, my point is going to be that somehow we've got to pull that together more. But then there's this ABA crowd of ag and food folks, which really brings some different perspectives than I think our group does. And I, that's just maybe a bigger manifestation of the tribalism we sort of experience in the United States these days anyway. But it is a bottom line problem, right? I mean, it is becoming a problem. And to that, Amber, next question right back to you. Proposition 12 is not a theoretical legal exercise. Proposition 12 is on the books, appears to go into effect this coming January. What's the play now? Now what?
You bet. And Joe Miller always is here to provide good challenge as well. So I've got a direct question from Joe, and I see another one in the chat box over here as well to everybody. Candidly, I think that the most direct strategy that the pork industry can take now is to advocate for an extension of the implementation timeline, right? Those rules and regulations are not yet final. They're still accepted. They're going to have, as I mentioned, the public meeting here at the end of August. I think that to the extent there is a strategy, that's got to be it. That let's extend the implementation deadline instead of quibbling about whether it was based on science or is based on welfare standards or if we should even do it. The reality is that it's in place, right? And it will be done. And so let's talk about that implementation deadline and be practical about when farms can comply, right? And pick a deadline that works for California and works for pork producers. That's going to be a push-pull. But right now, Ray, I think that's probably the only true challenge that can be made by the pork industry. Interested to see what Joe thinks, because he's been involved with this on the egg side as well.
Yeah, and I think great. I'm going to switch gears a second though, and go ahead and ask the next question. So Joe, in a little bit, I'm cutting you off here, but Paul over at the Biotech Center, which we have, Tiffany and Amber, a really good footprint in the state of not just the production side of agriculture, but also the biotech, the ag tech growing industry there as well. And so I think a great question for you, Jake, is we've talked a lot about this right to farm relating to farms, but are there bigger lessons here for auto mechanic operations, even a BSL lab, which most citizens don't realize is right down the street from them? What are the bigger implications for folks outside and off of the farm of this nuisance litigation?
Well, it certainly sets a pattern for how you could come after some of these other groups. Now, the thing that they don't have is a right to farm law to insulate them. So they're vulnerable now to those lawsuits and always have been. And I think the reason for that, as I said at the outset, is agriculture is uniquely vulnerable to these type of matters. And so that's where the genesis for those right to farm laws came from. But there was some discussion back during the 2017, 2018 legislative fights about whether you just make this right to farm law applicable to all businesses that are engaged in certain activities that could be subject to nuisance. That legislature wasn't too terribly interested in entertaining that, but the idea was at least pitched. So I think there's some merit to it. I think we would certainly support it. But the idea here is there are certainly, I think, Ray, the point you and I have talked about before is people are beginning to understand that there's money in agriculture. And when there's money somewhere, I hate to be talk bad about people in the profession, but there are people who like to go get the money that's available to them, and they use litigation to do it.
And they like to keep either a third or 40% of it, but
right,
but that's just my observation.
Right,
but,
and so as people, so my point is people see that there's money in a particular sector of the economy, they're going to go after it, and so to the extent that these other industries have that, they should be on notice.
Housekeeping point, Erica has asked about the material. It is our intention to be able to share the recording from today with folks who participated, so that'll be easy. Tiffany, I'm going to ask Erica's question to you in a minute, but before I do, let me stay with Jake a moment. There's a very practical question that you've probably gotten. That's the only reason I feel comfortable putting you on the spot, and let me do the housekeeping work of saying, Jake cannot be anyone on this call's individual counsel. But I can tell you, Jake, is what does it mean for the farmer who might want to subdivide part of their property, who might want to actually be a part of developing some land around their farm? How does that, what are the touchstones of how to be careful about that if you want to make sure you don't miss out on the protections of North Carolina's right to farm law?
I think you need to go get counsel and be really thoughtful about how you structure your deals, how you structure your properties, all those type of things. And it just makes sense to make the investment ahead of time. You'd rather get the front end support and help from somebody who's talented like Amber Miller, who can represent you, although not in North Carolina, although we'd love to have her here. So just put in that plug. But
yeah, and it's a great place to live.
Yeah, it is. It's a fantastic place. But we have good barbecue too. But the point of it is better than y'all's. But anyway, the point is having somebody like an Amber Miller, having somebody like, in North Carolina who can help you work through those transactions and help you think through it is really important. We at North Carolina Farm Bureau can't represent you, but I do know some attorneys in the state I can refer you to. But it's important. You got to do the planning ahead of time.
Yeah. Well, I can't leave that barbecue comment hanging. I do think ours is superior, but you could open a Fuzzy's Tacos in Raleigh if you came here, Amber. We would take one of those. You guys definitely do Tex-Mex better than we do. So with that said, Tiffany, the question about, what does the U.S. Supreme Court ruling mean about investigators and folks who presumably are lawfully entering to enforce potentially even criminal statutes? You've talked about this case a lot. That's a part of what you do, is tell farmers what are their rights with regard to third parties entering their property. Give us some guardrails there and just whet our appetite, if you will.
Yeah, I mean, and I'm going to be speaking extremely generally here, right? So big overview. I mean, in general, if people are coming on and there is some sort of authority that lets them do so, right? Whether that's a statute or, they're an investigator or something like that, they have the right to do that, then you want to be very careful how you act. So one thing is, in general, they're usually confined to sort of the public areas of the farm. So like they could come in, let's say it's a dairy, they can come into the front office. They can't usually go back into like the milking parlor, right? And so that's sort of a general observation. Certainly if there are any sort of biohazard or biosafety concerns, that's something you want to be really aware of. And that can be a limitation on where people can and can't go. The last thing I guess I would say is, just on a real practical level, you want to be really careful with your interactions with those folks, right? And you need to assume, because it's probably true, that they're being recorded. And so you don't want to come in there and act like a crazy person and get everything on camera, and the next thing we know, it's on the 5 o'clock news, right? So we do some work, and I know that there are other industry groups, our dairy groups here in Texas in particular, who do a lot of training on how to act when this happens, what to do, what people can and can't see, what paperwork you may need to have in place, et cetera. And so I think it's a big concern. And those are just some kind of overview things I could give you off the top of my head.
We're going to make sure folks can get up with each of you after the call. Tiffany, thanks so much for the time. Amber, Jake, same. Just a lot of wisdom here available to our chamber members and non-members who are always happy to welcome to these Ag Allies discussions. A couple of things in terms of wrapping up. We are over time. It looks like the conversation could go on longer, but we try to stay true to keeping the time. First of all, I have to say a big thank you to Natasha and to Talisa. Natasha is our events and membership, sort of straddles two different teams here at the chamber and helps us pull off these kinds of events. So flawlessly executed today. She shared there a slide which talks about upcoming conferences that we have here at the chamber. One of those, of course, I've got to draw your attention to is right smack dab there in the middle of the page, the Ag Allies Conference, which Amber and Jake have both spoken at before. And that we still hope to plan to have in person, but we'll have a virtual option. It's going to be at the McKimmon Center this year. So we really hope you can join us. It's about a half a day on a Friday. You can wrap up by about 1:30 that afternoon and be over at the State Fair by 2:30. So still gives you a lot of time that Friday to get to the fair. Let me also say thanks to Talisa. Talisa is the director of our events. I would also mention Talisa and the chamber help host events for groups outside of the chamber. So if you have event planning needs for your organization, we're happy to help out with that. The other thing I would tell you about Talisa, and I think it should endear her even more to the ag community. I know for a fact that Talisa has worked on a Sampson County tobacco farm. I have personally witnessed that myself, and so that brings her an even added level, I think, of credibility. But with that, thank you all for being with us. On your screen, you're going to see a poll that asks for some feedback in terms of what you thought about the event today. We will do another one of these in the fourth quarter. Not sure it'll be a legal topic, but we certainly got good feedback on that today. I do hope to see you personally at the Ag Allies Conference in October. We have a phenomenal program lined up with some very world-class and nationally known speakers coming in for that conversation. So I look forward to that. Thank you. Stay healthy. Have a great rest of the week. You know where to find us. Appreciate all of you. Take care.